I'm great.
Item 4, item 3, ma'am.
Lordships, the date of the charge sheet may be corrected. It is 19 July.
19 July, huh?
Lordships.
Charge sheet was submitted on
19 July. Lordships.
Item 3.
My lords, in item 3, I'm appearing for the respondent state, my lords. We have just entered my appearance yesterday, my lords. I'm just seeking 2 weeks for my reply, my lords.
They've been released on bail now, so we'll confirm the order.
I think that's all. I don't know much.
So, I'll stay.
My lord,
There's only one condition.
only one condition. Otherwise, there's an entry model which is in their favor.
On 6 September 2024, the following order was passed by this court. The petitioner has already been released on bail in connection with FIR number 123 of 2024, filed at PS Coimbatore City for offences allegedly punishable allegedly under the Tamil Nadu Prohibition of Harassment of Women Act 2002 and the Information Technology Act 2000. However, by granting him bail, the High Court directed that the petitioner shall close down his YouTube channel. We have reviewed that the imposition of such a condition was unwarranted and extraneous to the application for a decision on the application for bail. We have reviewed that the petitioner is released on bail independent of the conditions so imposed by the High Court. We accordingly set aside the condition which was imposed by the High Court to the effect that the respondent shall close his YouTube channel. The order dated 6 September 2024 passed by this court shall stand confirmed with the above clarification.
So there's the other conditions imposed by the High Court.
Only that condition we have
Grateful.
Item 4, my lords, the amount is not substantial, but this is a recurring issue, my lords.
75-day delay here. We'll dismiss it on delay and to keep the question of law.
My lords, because there's
a delay of 75 days on the part of the petitioners in challenging the order of the High Court dated 18 September 2023. Coupled with the above position of amount in the application for refund is only rupees 2.90 lakhs. We are therefore not inclined to entertain the special petition both on grounds of deal play and the minimal amount involved. However, while dismissing the special petition, we clarify that the question of law is kept open to be adjudicated upon in an appropriate case. 5. You have to issue notice and tag.
My lords, in this particular situation has occurred, my lords, pursuant to the Honorable High Court's order, we have been reinstated on 4/6/28. We have been rendering service of last 5 months.
Your lordships are considering this issue.
I'm only.
How many matters are there totally?
Totally about 16 matters are there.
16.
Yes.
But my lords.
Lord is showing.
My lords, in fact, the impugn order is
issue notice and tag.
Yes.
The Learned Standing Council for the State of Rajasthan shall furnish to the Court Master the consolidated list of cases which are pending before this court, list on a miscellaneous day on so and so. They list all the cases on a miscellaneous day. The only issue is whether the allopathy, the Ayurvedic and homeopathy and naturopathy doctors should have the same age of retirement as the allopathic doctors.
Well, in fact, the impugn order was passed based on North Delhi Municipal Corporation, Your Lordship, and the
that's why we list all matters together.
My lords, only one single concern in garb of this petition have not been paid for almost 5 months now. We are rendering service and they have
not been paid.
No, my lords.
That I will check.
I'm saying on instruction they have not. We are placed at the headquarters
by the Learned Council for the respondents that for the last 5 months the respondents have not been paid their salary despite the order of the High Court. We clarify that there is no stay on the operation of the judgment of the High Court, and in the event that the outstandings towards salary have not been paid, they shall be cleared within a period of 1 week, not only in the case of the respondents, but all similarly placed doctors.
Public.
But they are all working as Ayurvedic doctors.
I'll check this. I'll see.
With that, deprive them of their salaries.
I'll do.
Why this, stepmotherly treatment to Ayurveda?
The latest standardization is also the main matter not obliged.
Give that list today to the, just do that. Get the list. So 149 days.
I think there's a delay of 54 days.
149 days.
Let's see.
We'll dismiss it on delay. All that is being done is he has been told to be given. He's working as chairperson of the Haryana Pollution Control Board.
Please, madam.
The former judge of the High Court. High Court has said please give him the benefits at par with what the backward class commission chairpersons are getting. Otherwise, it causes a lot of heartburn. I mean, same retired judge of the High Court goes to the Consumer Disputes Commission, you give him something. Goes to the backward class commission, he gets something.
Give me 1 minute.
We'll dismiss them. Delay. That's all.
I appreciate minutes. Only a few sufficient.
But before you open that door, you have to come within time.
I appreciate, but it's in this matter actually. What has happened?
There's a delay of 149 days on the part of the state of Rajasthan, state of Haryana, in filing the special petition, which has not been sufficiently explained. The special petition is accordingly dismissed on the ground of delay.
But there are otherwise minutes. Kindly appreciate. The nature of work has to be seen. Nature of work may not.
Delay has to be.
But in the written statement, we have specifically said on.
They don't appoint retired judges. Don't appoint retired judges as chairpersons of the Pollution Control Board.
114 cases were filed in 2 years. Only 5 cases per month. And on the other hand, there are lots of.
Tell me one thing. What does he do? He's doing a job, right? How much can you tomorrow say that, look, as compared to this court has less work, so we'll pay 30% less salary.
But subsequently, in fact, we have notified in 2019, we have
the state of Haryana takes this attitude about the judiciary. The question is about maintaining the dignity of former judges when they occupy these positions. Question is not how much work is associated with the office. Don't appoint a retired judge.
But in that case, may I make one humble request?
We don't want retired judges.
But
once you appoint them, they must have a certain dignity about the work. They carry the imprimatur of having been judges of the High Court who come and work there. Question is not whether they do 5,000 matters or 50 matters. Question is the office.
Well, in this matter, there is a specific problem that we had notified the terms and conditions subsequently. Now, we have amended the rules. Now we have amended the rules, and in 2019 we have brought the notification that from day one the amount is specified. It has been brought in the
The question of law is kept open.
Please, my lord. This is what I.
In the future, it doesn't get it.
Please, your lordship, one more request. Delay in refiling may be controlled.
The refiling delay is controlled.
Obliged, my lord.
7 ho gaya.
7 matters.
6 sorry.
7 matters.
There is a delay of 531 days.
Additionally, it's also covered, my lords.
It's also covered by
Engineering Analysis
Center.
And the review has also been dismissed.
Besides the delay of 531 days in filing the special petition, the issue sought to be raised by the revenue is covered by the decision in Engineering Analysis Center of Excellence Private Limited versus CIT, covered by the decision of this court in so. 3 SCC 321. The Sublime Counsel appearing on behalf of the petitioner states that the review petition has also been dismissed. Petition is accordingly dismissed on the above grounds. Now comes
8, my lords, 8,
12, 13, 14,
21, 13.
They will all await our judgment in Tola.
All of them are Tola.
आपके पास सारा है ना?
It is, I appear for R1, my lordship may allow me to appear through VC.
Sure.
But we were not served when your lordship appointed.
Chinese company, right?
I am a Chinese company, my lord. We were not served when.
They are saying is, yes, Ms. Mehta, I got your point. What they are saying is that look, we have
Can I suggest something?
Arbitration, but they say that let the arbitrator be.
I was going to suggest that myself. I was going to suggest that myself, my lord. Lordships may have the arbitrator because lordships have appointed a very eminent arbitrator. Let the arbitrator continue, but let the arbitration be held under DIAC because, my lord, as an international
Mr. Jain,
If it could be an institution, my lord.
no problem. No.
And one more request, my lord. As far
That's
as,
very fair, Mr. Mehta.
as far as R2 is concerned, R2 is not a party to the contract. There is no arbitration agreement. Lordship may just make an observation that that issue is kept open for the tribunal to decide. Although in the act it is, but nevertheless, my lord, an observation could be made.
The application, Mr. Jain Mehta, Learned Senior Counsel, appears in support of the application for recall of the order dated 8 July 2024 passed by this court in exercise of under section 11 bracket 6 of the Arbitration and Conciliation Act 1996. Full stop. Though the ground in the application is that the applicant, which is a Chinese company, was not served with the notice of the proceedings. During the course of the hearing, it fairly stated that the applicant does not have any objection to the continuance of the arbitration under the sole arbitrator appointed by this court. Full stop. However, it has been submitted that the arbitration may be held under the auspices of the Delhi International Arbitration Center. And however, it has been submitted, kept bracket 1 Carlo, semicolon, and bracket 2, the implement, the issue of the implement of the second respondent may be kept open to be decided by the arbitrator.
So reply.
The original petitioners have no objection to the above clarification being issued. Hence, we direct as follows: colon bracket 1, the order of this court dated 8 July 2024 appointing a sole arbitrator is maintained, semicolon, bracket 2. The arbitration shall take place under the auspices of the Delhi International Arbitration Center, semicolon, and bracket 3. The implement of the issue of the implement of the second respondent as a party to the arbitral proceedings is kept open to be decided by the sole arbitrator should an application in that regard be made before
So deeply applied.
or in the course of the arbitration.
I am so deeply applied. Most grateful.
This has to be tagged with that matter which is pending before justice. No? They 3 weeks. They said after the Dashara holidays because of the book, what is for India.
My lord.
So, Jay, similar.
Now what I am praying for, my lords, is to have a separate national data grid for tribunals. If it has got nothing to do with the.
A similar petition instituted by the petitioner, petition 453 of 2024, been disposed of by this court in terms of the following order portfolio. In view of the above order, we are not inclined to another petition on the same subject. To stop, however, it will be open to the petitioner to pursue appropriate remedies available in law.
My lords, in fact,
item 14.
My lord, the seeker pass over.
By Mr. Tushar.
Short.
Who are you appearing for?
I'm appearing for the appellant. I'm being led by Mr. Tushar Mehta.
Tell us what the matter is about.
Yes, Your Honor. Your Honor, the matter is regarding, so it has been dismissed by NCALT.
Don't look at the back. We'll hear you as long as you want. No hurry at all. You argue. We want you to argue.
Communicate a message.
No, don't worry. We'll hear you. If you are inclined to dismiss your appeal, we'll wait for Mr. Tushar Mehta. You argue without any...
Yes, Your Honor. Your Honor, this is an issue with respect to the certified copy of the order being filed along with the appeal. Now, Your Lordships, we have in our submission filed a certified copy along with our appeal before NCALT. Your Lordships, if I can just give you a brief background, NCLT...
I'm sorry, my lord.
Mr. Tushar, Mr. Mehta, just 1 second.